Hello everybody, I'm here to talk to you today about the Hague Convention and in particular the Hague Convention on Child Abduction and how it applies in Thailand. First, some background. The Hague Convention is actually a series of conventions that are international conventions that are named after a very famous city in the Netherlands. But the particular convention or treaty that we're going to talk about today is the Hague Convention on Child Abduction and its Thailand counterpart. This convention was originally established and signatories signed on it way back in 1980. In Thailand, it did not become effective as far as applying it under domestic law until quite some time later, and we'll be talking about that in a little while. Why is this important? In family law, there's a great deal of disputes between parents in regard to child custody. As the world becomes more and more mobile and marriages involve people of different nationalities and residences, it often happens that one parent is aggrieved or believes that there's an issue with the children and will take their child or children across borders to another country. Now, what happened is that in the past, this created a difficult situation because without an international treaty that provided a uniform procedure between nations, it was very awkward, slow, and difficult to enforce a custody order across international boundaries. So there was seen a need to have a multilateral international treaty between nations that provided a streamlined and uniform way for one parent who has been aggrieved because the other parent has abducted the child, has a way to have the child returned. Now, Thailand, again, was one of the original signatories of the Hague Convention, the international treaty, but the Thailand government, the Thailand legislature, did not actually begin to implement this treaty by creating an internal domestic act or statute to effectuate the provisions in the treaty until much later, until 2012, and didn't start enforcing it until 2013. In fact, up until today, enforcement has been rather spotty, but as the Thailand government, the courts, the various agencies become more familiar with the treaty and its applicability, it's becoming more frequently used, and decisions of the courts are becoming more liberal in as far as being able to apply the treaty in various circumstances. So what is the basic requirements under the treaty? The first is that a parent who's been aggrieved because they have their children, one of their children or all of their children, taken from their particular national country to another nation state, can apply to a central authority. So a central authority is a particularly designated, usually a ministry or a department of a government that's charged with enforcing the Hague Convention. Thailand has its own central authority. So complaints are received by the central authority, and central authorities between different nations are in communication with each other. Now, what a parent has to do is they have to show to the central authority that their child was taken without their authorization and that they're requesting its return to their home nation, and in particular that their home nation is the habitual residence of that child. So one of the major things they have to prove is habitual residence. So obviously language, acculturation, family ties, social ties of the child to a particular nation is very important. When you actually apply for these cases, a social worker will do an interview of the child. So normally a complaint arises in one country, is sent to the central authority, and then the central authority contacts the central authority of another country in order to respond to the complaint and, if necessary, to proceed with the administrative task of enforcing the complaint. In Thailand, the administrative body that's charged with enforcing Hague Convention is the Attorney General's office. Nevertheless, sometimes the Attorney General's office or other agencies that are involved with or charged with the task of enforcing the Hague Convention, for one reason or another, don't follow through. There's also provisions in such a case for private persons to prepare and file their own petition to enforce the Hague Convention. The burden of proof is the same except for one thing. they only have 1 year from the date of the abduction and the taking out of the child from the country in order to follow through. So there's a 1 year time limit for private individuals to move or to enforce the provisions of the treaty. If the Attorney General does not accept the case, obviously it's better if the Attorney General files the case, because there are government agencies, and what it means is that the proof, the evidence involved, and the seriousness of the offense is high enough that the Attorney General deems that it's suitable to get involved. So that's one advantage of the Attorney General. If the Attorney General does not accept the case, it's possible to file for an appeal. Nevertheless, normally you would want to file a private petition with or without an appeal on the Attorney General's decision within 1 year. Always check with your attorney, because individual case facts differ, and different situations would require different remedies and different strategies. Okay, that's all we have for you today. Thank you very much for listening.